A very warm and cordial good morning to all the distinguished dignitaries, respected faculty members, honored guests, and dear learners of law gathered in this august assembly today. Your gracious presence adds immense value and significance to this occasion. I, Chirag Thakur, and my co-anchor Irtika Rahman, with utmost pleasure, welcome you all to this seminar on decongesting courts through mediation, evaluating India's path to speedy justice, organized by Center for Conflict Management and Dispute Resolution, Dr. B.R. Ambedkar, National Law University, in collaboration with India SME Forum. Justice delayed is justice denied. This truth echoes deeply within our legal system today. With over 5 crore cases pending across various courts in India, the quest for timely justice demands innovative participatory solutions, and mediation stands at the forefront of this transformation. Today's seminar seeks to explore how mediation as an alternative dispute resolution mechanism can serve as a practical tool to decongest our courts, enhance access to justice, and strengthen public confidence in the legal system of ours. As future lawyers, judges, and policymakers, it becomes our shared responsibility to understand not only the procedural aspects of mediation, but also its true potential to humanize and expedite the justice delivery. Today's deliberations will therefore move beyond theory to discuss practical dimensions, training of mediators, awareness building among litigants, institutional infrastructure, and integration of mediation into routine legal education. Before inviting the Honorable Vice Chancellor, sir, to deliver the welcome address, we are privileged to have the guest of honor for the day, Mr. Vinod Kumar, Honorary President of the India SME Forum, who will be addressing us virtually from the airport despite his demanding schedule. Mr. Vinod Kumar is a distinguished business strategy consultant and investor, widely recognized for his extensive contributions to the growth of Indian SMEs and startups. As a mentor, equity investor, and visionary guide, he brings profound expertise in equity investments, financial advisory, market research, strategic business growth, and international collaborations. His dedicated efforts continue to empower Indian entrepreneurs by transforming their aspirations into tangible success stories. Sir, you may address the gathering now. Thank you.
A very good morning to all my friends there. Honorable Justice Vinod Bharadwaj, sir, of the Punjab and Haryana Court, Honorable Secretary Dr. Rajiv Manisa, and Honorable Vice Chancellor Dr. Devinder Singh. Friends, I'm sorry I'm not able to join you physically, primarily because I'm supposed to represent it at the Global Industry Summit in Riyadh, so I'm at the airport and on the way to Riyadh. At the outset, I'm extremely thankful to Dr. Ashutosh Mishra, who has been a focused evangelist for micro, small, medium enterprises. And he has found multiple ways to support them effectively in legal resolution of by politician and the contribers and 98,000 members. And we are continuously engaged in supporting evolution of a conducive business ecosystem for micro, small, medium enterprises. For us, when we look at mediation and arbitration both, they are critically important for micro, small, medium enterprises in India because of the fact that they provide fast, cost-effective, and specialized dispute resolution mechanisms tailored to the unique challenges that most of the small enterprises in India have. All of us as MSMEs prefer mediation, sometimes arbitration also for several practical and strategic reasons, including that mediation can be arranged quickly and typically concludes later, faster than arbitration, I would say. The speed is crucial for micro, small, medium enterprises which are facing cash flow pressures, because we also need quick resolutions to payment and contract disputes. So overall, when you look at the micro, small, medium enterprises in India, we are talking about enterprises that have limited cash flows, very thin margins, and any prolonged dispute or payment delay can threaten the very basic survival of the enterprise and thereafter so so in terms of their employees and all the partners, vendors, and so on. The second point, which I find very important, is preserving or sometimes improving business relationships, which MSME mechanism is confidential, encourages cooperative dialogue, so very good option for us. Mediation and arbitration both under MSME specific frameworks are more affordable, obviously, or sometimes even free. So there's a reduction in terms of the financial burden on small enterprises and enabling access to justice. Litigation, as we all know, is expensive and it requires substantial legal fees and associated costs. Quicker resolution of disputes, normally what happens is MSMEs have this prolonged legal recourse. So mediation provides that. And we all know, as was talked about earlier, it is a great mechanism for reducing stress on the overloaded court system, which will enable the broader economy and the country to grow. Over the last 5 years, MSME's use of mediation and arbitration in India has shown distinct and evolving trends. On one hand, when we're looking at mediation as an increasing initiative like setting up dedicated mediation centers, integrating mediation into MSME FCs, the facilitation councils as they are called, and expanding access. We have newer frameworks, including the Mediation Act and the online dispute resolution platforms, which have professionalized as well as popularized mediation. Specialized mechanisms under the MSME Act also allow MSMEs to initiate dispute resolution without prior arbitration clauses and with fewer procedural hassles. In summary, I would say mediation and arbitration provide MSMEs in India with crucial tools to address disputes efficiently, affordably, and fairly, enabling them to focus on growth rather than legal battles. This overall MSME ecosystem can only be strengthened mediation and arbitration have become very important tools with growing usage among micro, small, medium enterprises in India. They are still emerging mainstream dispute. And there's still a little bit of time before they methods. The trend, however, I will say is very positive, and with expanding infrastructure and policy support,
Okay, proceeding forward. Thank you, sir, for taking the time to share your insights with all of us present here today.
Before we begin the proceedings, I take this opportunity to extend a warm and heartfelt welcome to our esteemed dignitaries seated on the dais. We are deeply honored to have among us the chief guest of the day, Honorable Mr. Justice Vinod S. Bharadwaj, Judge, Punjab and Haryana High Court, whose distinguished contribution to judicial reform and alternative dispute resolution are widely acknowledged. May I now request the Honorable Vice Chancellor, sir, to kindly present a sapling to our chief guest as a token of respect and appreciation. Thank you, sir. It It is also a privilege to welcome our special guest of honor, Dr. Rajiv Mani, Union Law Secretary and Secretary, Department of Legislative Affairs, Government of India, whose steadfast advocacy for restorative and community-based approaches to justice continues to inspire meaningful legal reform. I once again request the Honorable Vice Chancellor, sir, to graciously present sapling and memento to our special guest of honor. Thank you so much, sir. We are equally privileged to have with us our esteemed guest of honor, Mr. Vinod Kumar, Honorary President of the India SME Forum, who joins us virtually owing to prior engagements. Each lamp we light represents more than a flame. It embodies wisdom, hope, and the pursuit of enlightenment. As we commence this afternoon's proceeding with the lighting of the ceremonial lamp, we seek the illumination of knowledge to guide our path forward. In this spirit, I humbly invite the esteemed dignitaries on the dais to kindly proceed for the lamp lighting ceremony. May these glowing flames reflect our shared commitment to excellence, innovation, and purposeful progress in all our future endeavors. Everyone to please remain standing for the rendition of the University Kulgeet.
सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते जयति जय सत्यमेव जयते कर्तव्य भाव की वो दीक्षा अधिकारों की रक्षा मानवता धर्म निभाने की जन जन सुलभ रहे शिक्षा, इसको पाने के लिए सदा हम धर्म मार्ग चलते। जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते, जयति जय सत्यमेव जयते।
Thank you. You may kindly be seated.
Now, to mark the formal commencement of today's seminar, it is my distinct honor to invite our esteemed Vice Chancellor, Professor Dr. Devinder Singh Sir, a visionary academician and an eminent scholar in the field of law, to deliver the welcome address. Professor Singh's leadership has been instrumental in advancing both academic inquiry and institutional excellence at Dr. B.R. Ambedkar National Law University, Sonepat. His guidance continues to inspire our collective pursuit of legal scholarship that responds to the evolving challenges of justice delivery in India. May I now request, sir, to address the gathering.
Honorable Mr. Justice Vinod Bharadwaj ji, the chief guest of the day. Sir, I welcome you in the NLU campus Sonepat, and I am happy that you are here on this occasion to guide and bless our students. Sir is a judge with a difference. Being a teacher in Punjab University, Chandigarh, we are familiar with the working of the honorable judge and the quality of the judgment and quality of the hearing which does take place, and how the peers discuss, advocate, stakeholders and the litigant, that we know, and sir is being respected for this. Sir's court doesn't know 4 o'clock, doesn't know 5 o'clock, it knows the cause list, and that is known in Chandigarh in legal fraternity, and in Chandigarh also in Punjab University. Whenever we need sir for interaction with the students, sir always available. Sir, welcome here to interact with the students. Sir, these students need more guidance and more blessings for the reason that they are residential. They are in the residential campus. Most of the students are from the other states. Some are from the NCR region, including Haryana, but they are in the residential campus, and Saturday, Sunday, they have to function like this, and their working academic environment continues up to 8 o'clock, and after that their food and roaming here and there, and around 10 o'clock they go back to their rooms. This is their routine, sir. So they need more such legal luminaries, social people, so that they can more and have the benefit of a residential institution. Welcome, sir. Shri Rajiv Mani Tripathi ji, Secretary Law and Justice Ministry, Government of India. Sir, welcome here. And I think you have visited this campus earlier also, but during my tenure, this is the first visit. Law and Justice Ministry, we all look forward for many things. Now, sir has come. I hope in future we would be collaborating on the issues relating to justice, pro bono, and many other things which the Law and Justice Ministry has. We have only thing, we have the young minds and energy with them to work on. So if something is being handed over to us in the form of research, in the form of a campaign, in the form of other things, then we would be part of this. Sir, we look forward to this thing, and welcome in this campus, sir. Vinod ji, the head of the SME, who has addressed us recently, he could not be here, and he is more relevant for the students' future, for internships and placements. That is why we always make sure that whenever we have such function, we invite people from the market, because the ultimate goal of our student is to connect with the industry as well. He's also welcome. This program is being designed and organized by Professor Ashutosh, Registrar and Dean of this university, but he has some compelling circumstances at home, no doubt for his good only, So he is away today for this function, but today's function is being under his leadership and the whole team. We are working as per his instruction. The whole show was organized by him, and we are happy that he works overnight and he is connected from home until now, that that function goes well. So thankful. I'm thankful to him also that taking so much pain for the growth of this university. Surely, with the help of such type of help and the energy from the colleagues, the university will go up in the days to come. The teachers present here, the team, and the students, I welcome you all, and you are spending your Sunday, but this is a meaningful Sunday. I hope this is YouTube live also, so some of the students would be listening us online. Yes, they have some compelling need, but whatever is being deliberated here today, they must take it in their personal diaries. Sir, we have spread this function of Constitution Day from 22nd. Yesterday we have a function, and up to 6th of December, when the death anniversary of Baba Sahib Bhimrao Ambedkar takes place. And every day we have a function like this, so that all students, we have around 700 students in the campus, so all students are associated, either participating in the events or organizing the events as a volunteer. Purpose is that this 75 year of the Constitution is to be celebrated as such, that it should make a mark in the minds of the student. So they take some pledge that yes, they want to contribute towards the growth of this nation and the goals fixed by the Government of India for the Viksit Bharat. That should be achieved within time, or if we start working, it may be before the time. So with these words, I once again welcome the chief guest and the guest of honor, and congratulate everyone that you have organized this function on holiday, but this is meaningful holiday for you people. Thank you very much.
Thank you, sir, for setting the tone of the seminar with those insightful remarks.
It is my honor and privilege to introduce a distinguished guest who has made remarkable contributions to India's legal and institutional framework, Dr. Rajiv Mani, Union Law Secretary and Secretary, Department of Legislative Affairs, Government of India. An officer of the Indian Legal Service with a doctorate in Constitutional Law, Dr. Mani has previously served as an additional secretary in the Department of Legal Affairs. In his present capacity, he is entrusted with overseeing the drafting of central legislation, publication of laws, and vetting of subordinate legislation, in addition to playing a key role in matters relating to election law and electoral reforms. Dr. Mani has been instrumental in shaping several landmark legal reforms, including the amendment to the Arbitration and Conciliation Act, the enactment of the Mediation Act 2023, and the strengthening of commercial dispute resolution mechanism under the Commercial Courts Act 2015. His vision also guided the establishment of the Indian International Arbitration Center under the IIAC Act 2019. We now humbly request Sir to address the gathering.
Honorable Chief Guest, Justice Vinod S. Bharadwaj, Honorable Judge, Punjab and Haryana High Court, Learned Vice Chancellor, Professor Dr. Devinder Singh, Dr. VC, Dr. B.R. Ambedkar National Law University, Sonepat, the guest who had joined virtually, Mr. Vinod Kumar, Honorary President India SME, esteemed faculty members of the Dr. B.R. Ambedkar National Law University, Sonepat, and dear students. Indeed, I am privileged to be amongst you for the celebration of the Constitution Week, which is being undertaken by the university. And on this occasion, a very topical subject has been chosen, that is decongesting courts through mediation, evaluating India's path to speedy justice. I have been invited to this seminar by the learned Vice Chancellor and the Registrar also, Professor Ashutosh Mishra, who due to exigencies is not present. But the Center for Conflict Management and Dispute Resolution, which is being operated in this university, has made a phenomenal contribution in the study and examination of the Mediation Act. Professor Ashutosh Mishra was earlier in the Delhi University, and at that point of time, as Additional Secretary in the Department of Legal Affairs, I had the opportunity to join a big conference which he had organized during the COVID times on the benefits of mediation as an access to justice, as a tool of access to justice. So the good work which is being done by the university and its registrar under the leadership of the learned Vice Chancellor is commendable, and I congratulate the learned Vice Chancellor for his leadership in taking these steps forward. Today's occasion gives me an opportunity to speak to you about the various measures which are required to strengthen the ADR mechanism and ADR ecosystem in the country. I had the good fortune of being associated with the drafting of the Mediation Act 2023 and even the earlier legislations relating to alternative dispute resolutions, with a noble thought that the docket explosion which is happening in the country would be limited to a great extent if parties take recourse to the alternative dispute resolution mechanisms. Of course, mediation has a long history in India, right from the ancient days when it was a part of administering justice by the learned and wise men of the society among disputing parties. We find a reference to mediation even in the Mahabharata. Efforts to conciliation even in the Ramayana. And the long history of the Panch Parameshwar concept in our society, which survived till the colonial times, when the voice of the Panchas was given great importance, emphasis, and it ensured compliance of justice in the society. Subsequently, with the coming into force of the modern legal system, the faith of the parties in litigation, which is of course an adversarial adjudication system, gained traction. And I must compliment the judiciary of the country for having stood the test of time in the discharge of its duties and functions. Every person, every citizen in the country looks to the judiciary for access to justice, for speedy justice, and justice which is just, fair, and transparent. I'm really, I congratulate the university for their Kulgeet also, which is, I feel, is a manifestation of the principles which have been laid down in the preamble to the Constitution. The same preamble, the same goals which it sets for the country are a part of the Kulgeet of the university. I must compliment the authorities of the university for choosing such a topical and relevant subject of justice as a part of its Kulgeet. Coming back to the mediation ecosystem, so as I mentioned that mediation has a long history in our country, but due to the growth and strengthening of the adversarial adjudication system, which is of course the best way to resolve disputes, but given the pendency which is happening in the country, we have almost more than 5 crore cases now in different courts and tribunals of the country. And despite the best efforts of the government to augment the strength of the superior courts and the high courts and the state public service commissions to have the vacancies in the district judiciary filled promptly, the problem remains. Now, when we are striving to become a Viksit Bharat by 2047, a goal and a target set by the Honorable Prime Minister of India, Shri Narendra Modi ji. He also gave a call of Panch Pran on 15th August 2022 from the ramparts of the Red Fort to do away with the colonial mindset and develop faith in our own heritage. Growth of mediation law in our country is a manifestation of reliance on our own heritage. I need not elaborate on the benefits of mediation vis-a-vis other dispute resolution mechanisms, whether it is litigation. Litigation, of course, as I said, is the most preferred method presently of the parties, but it is time consuming, it is costly. And while we say you can initiate litigation, but you have no hold as to when that litigation will conclude. Whereas on the other hand, the mechanisms of arbitration, conciliation of course now is a part of the mediation under the, has been subsumed in the concept of mediation under the new Mediation Act. The act yet of course is to come into force fully, as the Mediation Council of India is yet to be established, which we hope will be done very soon. Recently the government has brought into force the 4 labor codes, which aim to bring and revolutionize the way the industry functions in the country and to ensure the welfare of the labor and women involved in the industry. If we see the developments which have happened in the last 11 years, as Secretary Legislative Affairs of the Government of India, I am proud to say that in the past 11 years, we have repealed 1577 obsolete legislations which had outlived their utility, had become archaic and were a burden in the statute book. We have been contributing in various decriminalization efforts of the government through the Jan Vishwas Act 2023 and the presently introduced Jan Vishwas Bill 2025, which is pending before the Parliament. We have been associated with the drafting of various rules which have done away with unnecessary compliance burdens, promoted ease of doing business and ease of living for the citizens. India's status as the 4th largest economy in the world and its target of achieving the goal of $30 trillion economy by 2047 cannot be achieved if we all work in silos. So from the whole of the government approach, now proceeding towards whole of the nation approach to achieve the targets of Viksit Bharat and make Indian standards as the global standards. The Prime Minister has always been very emphatic in highlighting that standards should be set by the country, which the world should follow instead of India following the global standards. With his inspiration and leadership, we are also progressing to achieve that goal. How to reduce the docket explosion of more than 5 crore cases pending throughout the country, which is a figure I have quoted on the lesser side. Mediation is one of the most effective tools wherein the outcome of the dispute resolution and the settlement which may ensue lies in the hand of the parties themselves rather than any third person. The mediator merely facilitates, irons out the differences between the issues raised by the party and brings them to a settlement. The new Mediation Act provides for various mechanisms for recognition of mediation service providers, mediation training institutes, and the creation of the whole ecosystem as to how the mediation would be done and concluded within a given time frame of 180 days, 120 plus 60 days. There are very few grounds to challenge the mediated settlement agreement which has been arrived with the consent of the parties and signed by the mediator. As young law students, You are leaders of tomorrow. And your leadership in the field of judiciary, in the field of legal advice, in the field of consultancy in legal matters is necessary and imperative to achieve the goal of Viksit Bharat. So I urge upon you that while you may try sincerely to achieve the goals set out by you for future, but also explore taking part as a full-time member of the arbitration bar or the mediation bar, which has recently been unveiled under the leadership of our learned Attorney General for India, Shri R. Venkatramani ji, as to how we can strengthen the ADR mechanisms and disseminate the benefits of these easily accessible aids to access to justice among the public. Conflict management is a serious issue in the country, and equally serious is the efforts to mitigate that conflict and bring the parties to a settlement. The idea of mediation, which has been subsequently formulated in the Code of Civil Procedure, Section 89, already is in working throughout the length and breadth of the country. We have mediation centers attached to various high courts of the country, even Mahila Thanas in various states. The efforts is to bring two parties to a settlement and dissuade them from taking the unnecessary route towards long-drawn litigation, which, as I mentioned, is time-consuming, costly, and the outcome is uncertain. Given all these benefits which the mediation holds for the country, for its citizens, and among the disputing parties, the ecosystem is already in place. What is required is the mindset, particularly from students, also from the advocates. The learned judges have been very, very supportive of this concept of mediation. Honorable CJI Designate Justice Suryakant ji, I had the privilege of sharing the dais with him when this moot court was inaugurated a few years back, has been a profound advocate for the growth of mediation in the country. He has always emphasized the benefits of mediation over the traditional routes of dispute resolution. And indeed it is an honor for the state of Haryana that one of its boy who has emerged from the rural background is going to occupy the seat of the Honorable Chief Justice of India. It's a great recognition of the merit of the state, and I would like all of you to please join me in welcoming the new CJI who is going to take oath tomorrow. So as young students, please, I'll urge upon you to give equal emphasis to the alternative dispute resolution mechanisms, given the benefits which it holds for the society at large. I'm also thankful to the learned Vice Chancellor, who on our invitation had joined us at a conference we had organized at New Delhi on the 31st of October last month. He gave his wholehearted support to the introduction of the subject of drafting of legislations as a compulsory subject in the NLUs throughout the country. While, as I mentioned, that obsolete and archaic laws are being repealed, decriminalization of compliance burdens is being undertaken. It is equally imperative that we should have good legislations in place. It is not that we are having bad legislations, we are equally having good legislations. But to highlight the importance of drafting, because when we were students, what we studied in drafting was actually conveyancing and drafting of pleadings. This is a different concept of drafting of legislations. And I'm sure that the Dr. B.R. Ambedkar University, National Law University under the leadership of Professor Dr. Devinder Singh would give us the full support and cooperation in research on various subjects of legislations which we will request the university to help us. I would also urge upon the students to develop interest in the drafting of legislations as it is one of the most crucial aspects of governance. For enhanced governance, for effective governance, we need good laws, and good laws need to be made on the basis of consultation. With the energy and zeal of the young minds collaborating in this effort, with their deep interest in research, with the empirical data which they have or which they can find out, we are certainly in a position to have more reforms in the country. There are several sectors which are in the need of reform. And the contribution of the young minds in those fields, identifying those sectors, identifying the laws which are an impediment in effective governance, and conveying the same to the government, while we also do the same thing, but we'll be happy if we get such suggestions from the students also, under the mentorship of their faculty, under the mentorship of the learned Vice Chancellor. I am really grateful for the Chief Guest to have contributed immensely personally in the efforts of dispensation of justice, as his timeline for the day ends when the cause list ends and not when the court clock ends at 4:30 p.m. This is a great contribution which has been made by you, sir, for the cause of justice, and I'm grateful and appreciate your honest and sincere attempts to further the cause of the justice in the country. I'm thankful again to the learned Vice Chancellor, Professor Ashutosh Mishra, for having invited me on this occasion to share my few thoughts on the subject of mediation and the related issues, as the ultimate goal is of Viksit Bharat at the rate of 2047, and all our collective efforts will surely see that we realize it much before it. Thank you very much. Jai Hind.
Thank you so much, sir, for gracing us with your presence. We are truly privileged to hear your insights and look forward to learning from your vast experience and wisdom.
It is with utmost respect and admiration that we welcome our Chief Guest, Honorable Mr. Justice Vinod S. Bharadwaj, Judge of the Punjab and Haryana High Court. Justice Bharadwaj stands as a shining example of judicial integrity and wisdom, consistently embodying the highest ideals of justice through his dedicated service. His leadership is marked by profound insight and unwavering commitment to the noble traditions of our judiciary. Justice Bharadwaj began his legal journey as an associate at Chandigarh Chambers of Law, later establishing his own practice in 2001. Over the years, he has held numerous esteemed roles, including as additional standing counsel for the Union Territory of Chandigarh from 2003 to 2009, and standing counsel for the National Council for Teacher Education. In 2010, Justice Bharadwaj was appointed Additional Advocate General for Haryana, and in 2014 for Punjab, serving in this capacity until 2017. His exceptional contributions and legal expertise led to his designation as Senior Advocate by the Punjab and Haryana High Court in May 2021. Justice Bharadwaj's distinguished career includes representation of various government departments and public institutions such as Punjab State Power Corporation Limited, the Haryana Electricity Regulatory Commission, municipal corporations, universities and public sector undertakings. He has also acted as a consultant to the Haryana Electricity Regulatory Commission and possesses extensive experience in arbitration matters involving several state entities. I humbly request, sir, to address the gathering.
Honorable Dr. Rajiv Mani, Secretary, Department of Justice. He is the person who appoints us as judges. Of course, it's a privilege for me to be here with him sharing the dais. Dr. Devinder Singh, Vice Chancellor, Dr. B.R. Ambedkar, National Law University, Sonepat, Dr. Mishra in absentia, the faculty members, the students who are here on account of compulsion. I can understand your pain. Seminar, that too on a holiday, that's the last thing which you would wish for. Let me try to make it in somewhat interesting manner, just in case you can come out of your mobiles and we can have a more participative session. Now the question, of course, we've always been talking about, Dr. Mani started with the reference of mediation from the Mahabharata era. Can anybody recollect what is that incident of a mediation attempt? Anybody can inform me that? That's right. So as the Rashtrakavi Ramdhari Singh Dinkar said, भीषण विध्वंस बचाने को, मैत्री की राह दिखाने को, that's his wording, भगवान हस्तिनापुर आए, पांडव का संदेशा लाए, दे दो केवल 5 ग्राम, रखो अपनी धरती तमाम, हम वहीं खुशी से रह पाएंगे, परिजन पर असी ना उठाएंगे. So that's the issue, that's the idea of mediation. You don't litigate. There is no adversarial thing. You try to settle it out. That's the idea. Now, why has this mediation or any form of alternative dispute resolution become essential? Why is it a call of the nation? We had to run a drive, mediation for the nation, which was initiated by the Chief Justice designate, of course, coming to the office tomorrow, Justice Suryakant as the national head of the Nalsar program. But what is the reason? Why this emergent need has come forth that the mediation has to be explored in such trajectory and in such proportions? It is because of a belief, a percolating belief that the court system as it functions today probably is not effective in delivering expeditious justice. We are often given the quotation that there are 5 crore cases approximately pending before the courts. I'm not the spokesperson for any of these systems, but let us try to understand the expanse of the problem that we have, the reasons why this has become a problem, and the different ways in which we intend to tackle that problem. Of course, one is ADR itself. So Dr. Mani would agree with me right since 1987 when the Law Commission gave its recommendation. The idea was, let us have some formula on the basis whereof we can determine what is the optimum number of judges that there should be in the country to dispense expeditious justice. The figure then fixed was 50 per million. So in that context, the sanction strength of judges currently, pan-India and in the judicial lower services, so appellate services, which is the Sessions Court and the High Courts, etc., was fixed at around 21,000. Add another 1,000 or 1,500 plus, so the total sanction strength currently is around 23,000. As against 23,000, nearly 30% of the vacancies at all levels, except the Supreme Court or maybe the percentage in the rest of the courts, is around 30%. So we are short of the judges by that number as against the sanction strength. The current population projections would require nearly 80,000 judges. That's the minimum benchmark for the country, and this was a figure way back in 1987 when 157th Law Commission report came. So this is what the future holds for you. There is likely to be immense potential for vacancies in the form of judicial offices to be held by you, which definitely would lie ahead, because that is what Government of India is intending to. For every robust economy, its effective and efficacy of dispute resolution has been the prime concern.
Just look at any of the developed economies, be that UK, be that US. With Lloyd Finance, that is when the UK controlled the global economy. They have very robust commercial laws, its implementation and effective mechanism for grievance redressal. So that's there. The similar is the pattern in US, in Europe. They have those laws on commercial matters, on economics, which actually focus on expeditious redressal of grievances, because money is the capital. More you circulate, more its capacity to generate employment. It regenerates. So that was the idea why we need expeditious adjudication in these matters. So when we're talking of pendency, we say 5 crore cases. We should understand what is the institution, what is the demography of litigation today. So in the country, average cases that are instituted every month is something around 10 lakhs. So we're looking at 1 crore plus cases which are being instituted in courts every day. The moment a case is instituted, we start counting it's a pendency. It is not. There is a minimum gestation period for every case to mature before it can be finally decided. So you have summary trials, they say minimum 6 months is required. You should not be saying it's a pendency unless that 6 months period has come to an end. Then there is civil disputes or certain issues which have to be decided expeditiously. They can be offenses relating to POCSO, there can be offenses relating to elderly people, there are offenses of NDPS, there are offenses pertaining to UAPA which are pressing needs. Commercial courts are there, which again timeline, there's a court management system or a case management system where timelines have been fixed. So the priorities get fixed, and the cases which don't fall in that priority, they take to the back benches. That is where the pendency piles up. So this is how it happens. These are the factors which add on to it. But what are the other factors which are essential for expeditious adjudication, but they are absent? The logistic support is absent. In our country, the problem starts, I'll just point out the problem, and then of course we'll try to focus on the solution. Of course, mediation is one of the aspects, and we'll enter into that area without taking much of your time. I'll be very brief. One is an over-implication, the other is false implication. Who can explain me the difference between over-implication and false implication, please? Yes? Anyone who is sleeping can answer? An over-implication actually is you aggravate the offense or attribution to a person. And a false implication is you import somebody, portray him as an accused. At times, it can be both. Resultantly, the job of the investigating agency becomes very difficult to ascertain who the actual culprit is. So we have this both. As lawyers tomorrow, once you are in field, would you adapt to this practice? Because the man is looking for justice. What he is wanting under the garb of justice is satisfy his vengeance. This is what actually propels the man against whom he is litigating to have to widen the net, to implicate as many people possible as he can. So the job of investigation becomes difficult. This increases the work of the court manifold. And that is where Justice Dhingra at one point in time said, the parties know the truth. It is the judge who is on trial. They know who is guilty, what his role is. So parties are not being tried. Both parties know. It's the judge who is on trial, whether he can decipher who is the actual culprit. But there is a complex maze which is made. Now this complexity is commencing from the informant, then to the role of the investigating agency, who is severely marred with the resources at its command. In the state of Haryana, the deficiency of resources, I can just give you an insight as to what is the gap between the investigation. So usually under the BNS or IPC sections or other minor offenses, there are around 50,000 cases which are registered. These are registered cases. You multiplied by 3 would be the number which are not registered. And there are more than 1 lakh of complaints which are being filed solely and exclusively under the Cyber and IT Act. The total sanctioned strength of police force in the state is around 50,000, which has approximately 700 gazetted officers, 790, 800 gazetted officers. Then of course around 5,000 who are non-gazetted but in the ranks of ASI till inspector. Then of course you have the constabulary, which may not have investigation powers except for minor offences or petty offences in like theft or whatever that. Now with the sanctioned capacity of 50,000, the actual police force is around 35,040, of which 10% is on leave for whatever reasons that they may be. So you have around 35,000 people who are on active duty, of which around 15,000 are those who are actually discharging or having investigating powers. Now this is the workload that has to be discharged by them, which is basically in addition to their law and order duties which they have to generally perform. He will never have the backing or the resources of the state to complete an investigation. Therefore, what he does is, you tell me the man, I'll file a final report. You ask me to investigate, I can't do it. I don't have the resources because he needs the support. That support may be the forensics. We don't have the labs. That support may be that he has to go to different places to collect evidence, to record statements. He will not get that financial support or that money. That in cyber crimes, the movement is very quick and fast. It runs through different states. So the law requires the person to be moving into each and every place, collect the primary evidence, record these statements, and then come back. But this may involve days. We don't have the manpower to spare for the days, and nobody is willing to finance him that sort of an expense, because then detection of crime and its investigation becomes costly. Then of course, the aspect of they're not being trained to investigate is another. One is they don't have the scientific backing. The problem gets aggravated because of lack of acumen. What to do? He's by and large a constabulary in Haryana. It's a matriculation which is required. They come up to the ranks of ASI, of course, a large number of them. But the thought process may at times have certain limitations. How to connect? What is the cybercrime it's an Zen alpha or Zen beta sort of a thing. Maybe persons belonging to the early generations, it is all Greek and Latin. One doesn't really know the difference, and instances have been there that they would take the output device and leave the entire ROM and the memory cards in the possession of the accused. So they were not even aware where the data is stored. So this is the sort of an investigation that they conduct. Then comes the prosecuting agency, which is the public prosecutors. They may be assistant public prosecutors, deputy district attorneys, the district attorneys. That becomes another area where there is huge understaffing. So the courts currently are working with the public prosecutors appearing on a time basis for 2 hours respectively in different courts. So he's handling 3 courts or 4 courts. Now this is all potential for you. These are the posts which are to be occupied by all of you as graduates of law. This is available. So once the public prosecutors are working on a part-time basis, they really don't get time to work on their cases. And by the time the evidence is recorded, the person is already moved on to the other court, and he's not in a situation to oversee the recording of evidence. This further delays. Now these are structured institutional delays. Then of course, as I pointed out, as against the requirement of 80,000 judges, the sanctioned is 21,000 odd. Actual working would be somewhere around 15 to 18,000. That is the figure which keeps fluctuating. This causes institutional delays. So these are matters which come before court. Now how to solve the problem? One, of course, you have to put your heart and soul into resolving the conflicts which are already before a court of law. The second is, if you are looking at 1 crore plus cases which are being annually filed before different courts, how to reduce that inflow of case. That is where mediation is being sought to be infused and ingrained in the system. In earlier times, or even in very recent times, the usual mediators in any family would be somebody's Jija, Sala, Mausa, Phupa. They are the family mediators. Let me tell you this. So dispute within the family, they would call, chalo Jija ji ko bula lo ya Phupa ji ko bula lo, he will resolve it. He is assumed to be neutral. I think you can all relate to this. And there can be some mediator, unsung, unnoticed. You are going on a road, you hit somebody, you are about to have a fight, somebody just comes in, he says, चोट तो नहीं लगी ना भाई साहब किसी को, चलो कोई बात नहीं, हो जाता है, चलो चलो. What he has done effectively, he has mediated a dispute. He has diffused that situation into aggravating into an actionable claim. At times even police does it. So, but its ways and mechanisms are slightly different. So the injury is grave, person is hospitalized, पुलिस वाला कहेगा साहब क्या करोगे अभी 4 महीने आप कोर्ट में चक्कर काटोगे 6 महीने ये काटेंगे कहाँ परेशान होगे. Now the parties do settle at times, but why this is not accepted as a mediation? Because it does not leave a satisfaction in the mind of a person who has actually accepted the dispute, because somewhere down the line he feels one of the party has been cheated by some person, maybe the police person himself. साहब 20,000 रुपये मुझे दो मैं 30 मिनट का सेटल कराता हूँ, and you try to patch up things, but then there is a transaction in between. In the family unit there is no transaction. Therefore both the parties, even though they have resolved the conflict, or in the earlier instance of a road rage, there is no transaction. Therefore both the parties have gone, the dispute is down and dusted, and everybody is satisfied. In this process, the third instance or the example that I gave, in this process, even though the dispute has not reached the court, it does not give you the satisfaction of the dispute having been resolved. It still leaves a sour taste in your mouth. So these are different forms of mediation that you often see. The problem which happened with this form of a mediation is that notwithstanding this mediation having actually been achieved, one party becomes dishonest. They say, "Hua to tha, main nahi manta." And he then goes, files a case, bringing it back to the fora of adjudication, making it an adversarial litigation, attributing motives. I don't believe, I did not sign, I was under pressure, it's a fiduciary relationship, I was pressurized my brother-in-law to enter into this settlement, or so and so. Whatever grounds that as lawyers we can always cook up. I've been a lawyer all my life, so I can relate to that. So we cook up those false motives. This makes the task even more difficult. It is in these circumstances that the Mediation Act was thought of. Dr. Mani, as he told, he has been instrumental in drafting the act. It just takes away that factor of challenge to a settlement by a structured mediation so as to make it an effective decree. It's executable. The earlier settlement was not executable in case the parties did not wish to. Under the Mediation Act, once you have accredited mediators or the process is taken as per the procedure so prescribed in law, through an institutional mediation, through online mediation, or through whatever forms an agreed mediator, this then becomes a binding document which can be executed through a court of law. So therefore, that element of any party wanting to run off and not abide by the decision as taken in the mediation is reduced. So the idea behind the mediation as a means of decongesting the courts was this only, so that the inflow can be checked or reduced to a certain extent, because research shows that while it will take about 3 to 5 years for a matter before a court to be resolved finally into a decree, of course it will have appellate and revisional jurisdictions and challenges ahead. It takes about 3 to 5 sittings in a mediation for it to be finalized. So it's a huge time-saving exercise, and usually 30 to 35% disputes, when they are brought to a mediation, they are minor petty disputes, they get resolved. So this is a huge number. If we are talking of 1 crore cases to be coming up, you are talking of 30 lakh matters which can be decided. So one is, now we are tackling the situation, or the idea is you address it headstrong, both way. One is pre-institution stage. The second is capacity building and adjudication. So these are two things, and unless we hit it on both sides, we cannot reduce the backlog. Although Punjab and Haryana High Court for last 4 years has been deciding cases more than the institution, let me share that with you. So the annual decision is maybe around 106 to 110% of the institution. So as against 1,80,000 cases which are being annually filed before the High Court, the decisions far exceed that. So it's a process, but of course, based on a governmental support and the vacancies being filled up, yes, it does catch up. So this is the decongesting mechanism. Parallelly, there are different other statutes where we have a mediation concept. So you've all heard of Legal Services Authorities Act. Before a dispute can be adjudicated, a conciliation effort is to be made. Similar provision is also there under the Micro, Medium and Small Enterprises Act 2006, Section 18 deals with it. It says first a settlement process has to be initiated. Only in case it fails, then the arbitration will go on. Similar issues also there, a pre-litigation stage is already prescribed for under the Commercial Dispute Resolution Act. In matrimonial laws, of course, now we are trying to have a mediation, and it is being made as a part of the system that parties are sent for a mediation and conciliation of their dispute. We have in-house counselors are being recruited and inducted so that those minor disputes can be resolved. Then, of course, the Family Areas Negotiable Instruments Act and minor commercial disputes, where the issue is primarily on quantification. It is not a dispute which is complex in nature. It is only a quantity-based or evaluation-based dispute. You can always resolve it. ₹1 kam, ₹2 zyada. Anybody who's business acumen and sense would always be in a situation to quickly remedy. He can calculate कि 2 साल मुकदमा करूँगा, उसके बाद अगर मुझे 1 लाख मिलेगा तो आज 80 ले लो. So that's the settlement. That is how it goes around. So these are issues, but they can definitely be resolved. So in a concerted effort, mediation is being looked forward as an essential aid to decongesting the courts. While the courts can focus on more integral issues, core issues of dispute resolution, where adjudication and adversary parties are there, they have to seek a resolution on each and every issue. Effective it has been. Of recent, we referred in the High Court, at least that's just a tip of the iceberg sort of a thing which I can point out, that nearly 50,000 matters were referred to mediation with a success rate of around 25%, so nearly 10,000 matters got resolved. And national Lok Adalats are being held, which again lead to a lot of settlements. But they are saving not only on judicial time, but also on optimum utilization of resources and the man hours that go into it. The judgments have to be typed, they have to be dictated and corrected. In case you just want to understand what a judge's work would be, that each judge is, on an average, he's dealing with a docket of 125 to 130 cases a day. For a student's gumption, it is like you are reading a book of 200 pages every day. Then you have to dictate orders and judgments. That is like writing a book of 300 pages every day, and then correcting the same book which you have dictated of 300 pages. So this is the volume which each judge has to do on a daily basis. You can relate that. Try reading one book every day of your choice, and the judge doesn't have a choice of the book, right? Whatever comes before him, he has to read it and he has to decide it. So this is how the system works, and the volumes that are there, the time constraints that are there, because eventually he has to work with a steno. Maybe he can dictate more, but the person who has to type doesn't have the, I'll dictate, let us say 6 minutes per page. That will be the pace at which I'll dictate. But for typing that page, he requires 25 minutes. And for correction of that page, I'll require another 10 minutes. So this is a 40-minute job for one page to be corrected and finalized. So you have limited working hours. It's a 24-hour day. So this is the volume that we are looking at on a daily basis for a judge. And going at this pace, assuming this backlog is to be cleared, it will take another 25 years for the entire capacity to be working full time. And that is when there is no fresh institution. So mediation is a tool. We have now structured it. We have trained mediators. They are being included in the process of dispute resolution, and they have been effective. Therefore, once their efficacy percolates down into the masses, probably this system would gain the public confidence and would definitely work as an effective mechanism for dispute resolution. Thank you so much. It was nice being here. That's all for me.
Thank you, sir, for gracing us with your esteemed presence today. Your insightful address.
Beta, just a minute.
I'm so sorry.
Sir, with your permission. Sit down, please. Understanding this mediation concept, we need to do two things immediately by the mediation center. One is having a training program of 40 hours with the association and under the guidance of High Court. And once we had that program of 40 hours, then we have some trained arbitrators, then which is a pre-requirement to establish a mediation center in the university. So I hope we would be able to do this within the next 6 months. Let us have a target of 6 months, and prerequisite is training program and then a mediation center where student also get some exposure that how the cases are being settled down. And I hope with the recommendations of sir and everyone in the court, sir, nahin sir, aapko keh raha hu. Honorable Chief Justice of India, Justice Suryakant ji, is the visitor of our university, is the topmost administrator of our university, and in Haryana, we take pride that he is now the Chief Justice of India. Things would be smoother for us for getting this kind of thing. Yes, sir. Because he's the visitor sitting at the helm of the affairs, at the top of the affairs. So we as a only university in Haryana, National Law University, one among the 27 university, will take lead in many other fields also, including arbitration and mediation. Thank you very much, sir.
We extend our sincere thanks to all our distinguished guests for their gracious presence, for enriching the seminar with their invaluable insight and wisdom.
Moving forward, once again, thank you, sir, for gracing us with your esteemed presence today. Your insightful address, particularly your explanation of the concept of mediation and the issue of institutional delays, and the pathways through which we can resolve them, will undoubtedly leave a lasting and meaningful impression on all of us present here today. Moving forward, as we draw this memorable event to a close, it is my privilege to invite Dr. Deepshika, Assistant Professor of Law, to deliver the vote of thanks. Dr. Deepshika possesses a robust research background with 16 publications in UGC-listed and peer-reviewed journals, alongside several paper presentations at national and international conferences. Her academic career is distinguished by active involvement beyond teaching, having successfully organized numerous moot court competitions, seminars, conferences, and special lectures that foster holistic student development. In recognition of her valuable contribution to the National Law Day celebrations, she received an appreciation letter from the Law Commission of India as well, underscoring her commitment to academic excellence and the legal profession. I request you to kindly address the gathering with your vote of thanks, ma'am.
Good afternoon, everyone. It is my privilege and honor to deliver to vote of thanks on behalf of Dr. B.R. Ambedkar National Law University, Sonepat, and Center for Conflict Management and Dispute Resolution. At the outset, I extend my heartfelt gratitude to our chief guest, Honorable Mr. Justice Vinod S. Bharadwaj, Judge Punjab and Haryana High Court, for gracing this seminar with his distinguished presence and for sharing such profound insights on the emerging role of mediation in strengthening India's justice delivery system. Your valuable reflections on institutional reforms and the importance of dialogue in dispute resolution have deeply inspired every participant here. Our sincere thanks are also due to our special guest of honor, Dr. Rajiv, Secretary, Department of Legislative Affairs, Ministry of Law and Justice, Government of India. Sir, your address enlightened us about the vision behind the government commitment to institutionalizing alternative dispute resolution and mediation as a cornerstone of accessible and speedy justice. We are grateful for your presence and guidance. We also express our gratitude to our guest of honor, Mr. Vinod Kumar, Honorary President of India SME Forum, who despite his busy schedule joined us virtually and enriched the seminar with his invaluable perspectives. Sir, your observations on the role of mediation in resolving business and commercial dispute, particularly for MSMEs, added a crucial practical dimension to today's disclosure. A special note of appreciation goes to our Honorable Vice Chancellor, Professor Dr. Devinder Singh, whose visionary leadership, steadfast support and encouragement continuously inspire us to pursue excellence. Sir, your commitment to advancing ADR education and strengthening institutional capacity has been the driving force behind the initiative we celebrate today. We also extend our heartfelt gratitude to our Honorable Worthy Registrar, Professor Dr. Ashutosh Mishra. In absentia, sir, your administrative guidance, constant cooperation and unwavering support have been instrumental in ensuring the smooth and successful execution of this seminar. Your efforts often work silently in the background, but their impact is felt in every well-organized event in our university. As a university deeply committed to innovation in legal education, we take pride in sharing that mediation is a part of specialization in our LLM programs, reflecting our conviction that the next generation of legal professionals must be adept not only in litigation but also in dispute resolution that fosters reconciliation and efficiency. Furthermore, I would like to acknowledge the tremendous efforts of our Honorable Vice Chancellor and Honorable Registrar, sir, whose leadership has paved the way for significant institution collaboration. It is a matter of great pride that our university had extended into collaboration with the Indian Institute of Arbitration and Mediation, IIAM. Through this collaboration, our students will receive specialized arbitration training, gain hands-on exposure to real cases under professional arbitrators, and participate in capacity building programs that will strengthen their practical area skills. In addition, the university had in discussion with Singapore International Arbitration Center, SIAC. This engagement is expected to be soon materialized into an international online lecture series offering our students access to global arbitration expertise and world-class academic interactions. These collaborations reflect the progressive vision and tireless efforts of our university leadership, and they reaffirm our commitment to delivering national and international exposure in ADR studies. I would also like to extend my sincere appreciation to the Student Convening Committee for all the dedicated student volunteers. On behalf of organizing committee, I thank all our eminent speakers, faculty members, non-teaching staff, IT cell and participants for enriching today's seminar with their insightful discussions and thoughtful engagement. As we conclude, let us carry forward the spirits of today's deliberations, the belief that justice is not just a verdict pronounced in a court, but a bridge built through dialogue, empathy and understanding. Thank you all for your presence, your participation, and for making this seminar a meaningful step towards realizing the goal of speedy and accessible justice for all. Thank you so much.
We are deeply grateful to you, ma'am, for your encouraging words and your gracious presence throughout the event.
As we bring this seminar to a graceful conclusion, I request everyone present to kindly rise for the national anthem. Let us stand together in respect and reverence.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे, गाहे तव जय गाथा। जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
Thank you so much. May I now invite the dignitaries seated on the dais to kindly step forward for a group photograph with the distinguished audience gathered in this august assembly.
Yes, sir.